Hello and welcome to today's episode of Tax Decoder. Myself Anil Diwan, the founder of Tax Chanakya, and in this session we are going to discuss a recent Delhi High Court case that deals with a very practical issue in taxation, that is how joint ownership of property should be treated when the ownership shares are not clearly defined as in the sale deed. The case is Shivani Madan versus Principal Commissioner of Income Tax Delhi, decided on 8th January 2025. It's a very interesting judgment. In March 2011, a property in Saket, New Delhi, was purchased jointly by Mrs. Shivani Madan and her husband. The sale deed executed in the joint name of husband and wife, but it did not mention what percentage each of them owned. According to Shivani, her contribution toward the purchase was 20 lakhs rupees. In the assessment year 2011-2012, while her husband arranged the remaining funds, including loans, for the time this was not an issue, but during the search action, the tax department reopened her assessment under section 153A of the year 2015-2016, 2016-2017 and 2017-2018. Assessing officer took the position that because both the names appeared on the deed, Shivani should be treated as owning half the property, that is 50% of the ownership, and she was taxed on 50% of the deemed rent income from the said property under section 23 subsection 1 clause A. Her appeal before the Commissioner of Income Tax and the Income Tax Appellate Tribunal were dismissed. Both authorities repeated the view that she was a 50% co-owner of the property. Now when the matter came to the High Court, the judges asked a very important question: can a taxpayer automatically be treated as a 50% owner just because she or her name is on the deed, when the deed itself does not mention the ownership ratio? The court emphasized that section 22 to section 27 of the Income Tax Act from a complete code for income from house property. This provision says that when the shares of co-owner are not defined and ascertainable, each is taxed on their actual portion of the contribution. But when the shares are not clear, you cannot mechanically presume equality. In Shivani's case, the court observed that she had indeed contributed 20 lakhs rupees and her real share had to be determined with reference to the contribution and supporting records, not by guesswork. The High Court therefore allowed her appeal and set aside the order of the assessing officer, the commissioner and the tribunal. It held that the assumption of equal ownership was not justified and that without clarity in the deed or other conclusive evidence, the department cannot simply divide the ownership 50-50. The implication is straightforward. If you are buying property jointly, it is essential to state the ownership ratio clearly in the deed, that is the sale deed which has been registered, because otherwise the tax authority may draw incorrect assumptions. The judgment is significant for both buyers, taxpayers, professionals. For taxpayers, it highlights the importance of documenting your actual contribution, whether through bank statement, loan records, or agreements. For tax officer, it reminds that the substance matter more than form. Who really invested and who enjoys the income is what counts. For legal advisor, it is a lesson in drafting. Always specify the ownership percentage to avoid the dispute. So in summary, the Delhi High Court clarified that mere joint name on sale deed do not means equal ownership. Ownership must be either be clearly stated or provided through evidence, and taxation should follow the real share, not an arbitrary assumption. That's all for today's episode. I am Anil Diwan, the founder of Tax Chanakya, and I hope you found this case breakdown both informative and practical. Thank you for turning into Tax Decoder. Until next time, stay curious and stay informed.